Get ready. 3 seconds. 2 seconds. Start. A young mother of 2 kids, ran into the rail in front of a running train to end her life as well as her miseries once and for all. Full stop. She was driven to that action on account of the cruel treatment suffered by her at her nuptial home. Full stop. But destiny also was cruel to her as the locomotive which she desired to be her destroyer, instead of snuffing her life out in a trice, converted her into a veritable vegetable. Full stop. She lost her left hand from the shoulder joint and got her spinal cord ruptured. Full stop. She turned into a paraplegic. Full stop. She herself described her present plight as a living corpse. Full stop. Her husband, father-in-law and mother-in-law were convicted by the Sessions Court under Section 116, read with Section 306 IPC, besides Section 498A. Full stop. On the first count, they were sentenced to rigorous imprisonment for 2.5 years and a fine of rupees 10,000 each. And on the second count, they were sentenced to imprisonment for 2 years and a fine of rupees 5,000 each. Full stop. When the appellants filed an appeal before the High Court in challenge of the said conviction and sentence, the victim also made a motion before the same High Court as she felt that condign punishment had not been meted out to the guilty persons. Full stop. Both were disposed of by the impugned judgment delivered by a single judge of the High Court of Punjab and Haryana. Full stop. The findings made by the Sessions Court were concurred with by the High Court. Full stop. However, an altercation was made by substituting Section 306 IPC with Section 304B IPC to be read with Section 116 IPC. Full stop. Para. It is a unique legal phenomenon in the Indian Penal Code that the only act, the attempt of which alone will become an offense. Full stop. The person who attempts to commit suicide is guilty of the offense under Section 309 IPC, whereas the person who committed suicide cannot be reached at all. Section 306 renders the person who abets the commission of suicide punishable, for which the condition precedent is that suicide should necessarily have been committed. Full stop. It is possible to abet the commission of suicide. Full stop. It would be preposterous if law could afford to penalize an abatement to the offense of mere attempt to commit suicide. Full stop. Para. Learned session judge went wrong in convicting the appellants under Section 116 linked with Section 306 IPC. Full stop. The former is abatement of offense, punishable with imprisonment. If offense be not committed, full stop. But the crux of offense under section 306 itself is abatement, full stop. In other words, comma, if there is no abatement, there is no question of the offense under section 306 coming into play, full stop. It is inconceivable to have abatement of an abatement. Para. We therefore conclude that the appellants cannot be convicted under section 116 IPC either by linking it with section 306 or with section 304B, full stop. Hence, the conviction and sentence passed on them under section 116 IPC is set aside, full stop. The sentence of imprisonment imposed on the appellants shall stand reduced to the period which they have already undergone, full stop. We enhance the fine part of the sentence for the offense under section 498A IPC to rupees 1 lakh each for all the 3 appellants, full stop. They shall remit the fine amount in the trial court within 3 months from today, comma, failing which each of the defaulters shall undergo imprisonment for a further period of 9 months. Stop.